everyone, my name is Helena Birt, and welcome back to Litigation Help. Our video today is on motions in family court in Ontario, Canada, and specifically, what is a 14B motion? Joining me here is our regular guest, Helena Birt. Welcome back, Helena.
Hey, Heather, it's nice to see you again.
So, Helena, I thought a motion is a motion is a motion, but then I hear my family lawyer colleagues, they mention, oh, we're going to do a 14B. And I'm like, what is a 14B motion exactly? But anyway, before you even get there, perhaps you could start us off by refreshing our minds just briefly what a motion is.
Okay. Whenever a court proceeding is started, and again, I'm focusing now on family. So if I don't say
Family,
family, it's just my experiences. We're talking about family, but some of the stuff is
right?
pretty general. Anytime that a court case is started,
Yeah.
sometimes parties say they need an order made on a temporary basis because they can't agree to a final order on consent right away. And they're asking for a temporary order because they need something in place to deal with an issue right away. They can't wait until a final order is made after the end of the trial. So if you're looking to try to get a temporary order or like a procedural type of thing in the course of a proceeding, what you need to do is bring a motion. So what you're doing is you're asking the court, it's a formal request for an order or a ruling on a specific issue within a case. So the case is still generally ongoing. The
Hmm.
motion is in the overall proceeding process, and you bring the motion when you're asking the court to make a formal order or a ruling on a specific issue. So when we're talking about motions in family court in
Hmm.
Ontario, that's governed under the family law rules. Everything is
Okay.
governed by the family law rules for process.
Hmm.
And the specific rule that applies to motions is Rule 14. So under Rule 14, it tells you what kind of things you can do. So under Rule 14, sub 1, as it specifically says, a person who wants any of the following may make a motion. One, a temporary order for a claim made in a motion. Let's say it's a claim for child support. You could ask for a temporary order for child support. Two, directions on how to carry on the case. Parties, or they might have hit a point and they're not sure what they have to do next, and the rules aren't really quite clear. They can ask the judge to make a ruling on a direction for what is the next step that they should do and what should be the next step in the process.
Hmm.
Or three, if there had already been a temporary order made in a proceeding, then you can bring a motion to change that temporary order. So you're dealing with things where you're asking the judge to make a decision on something in the middle of the case process, because you know it's either going to eventually either settle or it's going to go to trial, but you're trying to get stuff sorted out right now. So that's what you do, is you bring a motion asking for temporary relief. Okay, so again, with the terminology, if you're
Okay.
the party who's asking the court for a motion, you're bringing the motion, then you're referred to as the moving party because you're the one that's making the motion. So you're the moving party. The other party who's responding to the motion is called the responding party. Now, the thing to keep in mind is because this is taking place in the overall context of a case. So that means, like generally in family court, everything is started by an application. And under the application, you have one party named as an applicant, the other party is named as the respondent. That's what we call tombstone information. That information never changes. So that sets the overall context for the case itself and the court file number, as long as it's going to court in the same jurisdiction. It will always have that same court file number. So what you have to keep in mind is, let's say that you are the applicant, you've brought me to court on an application and I'm the responding party. I decide I need a temporary order about something. So I am bringing the motion. So I'm still the respondent, but I'm the moving party. You are the applicant, but on the motion, you're the responding party.
Mm.
Or if you're the one that decides you have to bring the motion, you're the moving party, and you're still, as the applicant, you're the moving party, and I'm the responding party, and I'm still the respondent in the case. But you have to keep in mind, don't get those two confused. Like the moving party and the responding party are who's bringing the motion and who's responding to the motion, but it doesn't change who is the overall applicant in the case and who's the respondent in the case.
That's
So clear as
interesting.
mud so far?
Yep, good. Okay.
Okay, So then there are also different kinds of motions. And this was kind of an interesting discussion you and I got into before we started filming.
Mhm.
These aren't all totally mutually exclusive, but the terminology you're going to hear when motions are being referred to,
Mhm.
the main different types of motions are, first of all, motions on consent. So a motion on consent means that one of the parties is bringing a motion. So one party is still the moving party, the other party is the responding party, but the responding party is agreeing to the order that the moving party is requesting. And they do that even before the motion is brought. So that's a motion on consent where they're putting a thing before a judge and saying, hey, judge, we need the moving party is asking for this. I'm the respondent. I'm agreeing to what the moving party is asking for. So this is going on consent. We're not arguing about it. We're not disagreeing. And there are just sometimes you need that order because you might need the order like for a third party, like a bank. If you were looking at refinancing or for release of information or anything else, they're going to say, hey, we want to see a court order. And if the parties agree that they want the bank to produce whatever it is they have to produce, the parties can go to the judge and ask for an order on consent, asking for that order to be made. So that's why I think one of your questions was, if the parties are agreeing, why do they need an order? Well, because sometimes it's needed for a third party. And the other thing is once parties are agreed, you want to have it formalized in an order, because what if one of the parties changes their mind or gets buyer's remorse? They might have negotiated and agreed to something, and the other party said, I really wish I hadn't agreed to that, so I'm not going to agree to that anymore. So that's why you get an order on consent. So it locks in what the parties have specifically said they've agreed to. Okay, the alternate to that is a motion without consent. And this is what you normally think of when you think of a motion. It's the moving party wants the court to do something, to make an order on an issue.
Mhm.
The other party disagrees with what the moving party is asking for. And in that case, the motion is happening without consent, which means that there's going to be an argument and it's going to be a dispute, either in materials that are filed with materials going back and forth, or they're going to get up and argue on their feet in front of a judge with the moving party asking for A, the responding party asking for B. So that's when the parties aren't agreeing. So as an example, if there's an urgent motion, where let's say that you have a parent is overholding a child. There's
Mhm.
an order that says that the child is supposed to be with one parent and return to that parent on Sunday. The other parent refuses to return the child. I think we've done a session on urgent motions.
We
Then
did.
that kind of urgent motion is a motion that's happening without consent. So an urgent motion where you give the other party notice that you're bringing to it,
Mhm.
or that motion, or you're doing an urgent motion without any notice at all. The third type, and this is where we start actually getting to what we're going to be talking about today,
Mhm.
are a motion for a procedural or an uncomplicated or an unopposed matter, which is like basically like on consent, but it's procedural. So these are the motions we refer to as 14B motions. So normally when you're bringing a motion to deal either on consent or not on consent, then the form that you would normally use is a Form 14.
Mhm.
When you're doing something that's procedural and it's uncomplicated, it might be on notice to the other side. It may not be on notice at all because it's strictly procedural and something you need to do. They decided courts don't need to waste their time by having people do a motion and file it and have it scheduled to be heard in front of a judge. There are things that can be done just on the basis of paperwork. And if they're procedural, chances are they're not going to be contested, or they're very, very not complicated. The judge can just go ahead and do it by reading materials in his or her office. And it can go through as what we call a basket motion, because it used to be in the days of paper, you would actually file your 14B motion at the court. It would go up before the judge would read it. Nobody would have to appear, nobody would have to say anything, and the judge would then make an order, write out the judge's his or her endorsement
Mhm.
about just based on the paper that was filed on that motion. So what they decided to do in family court because they didn't want to get it caught up in the normal process for a motion that's going to end up actually being spoken to in front of a judge or that's going to be argued or anything else, they created a special motion form. So the normal motion form is just a Form 14.
Mhm.
They created a Form 14B, and that's what they call it. It's a 14B motion form, which gives everybody a heads up that this is a motion that's being brought for a procedural or an uncomplicated or an uncontested matter. And it can just go through paperwork. It doesn't go on a motions list to be argued, or nothing else happens. And that's what we're talking about today. It's a very useful tool because it saves you a lot of time. It gets you the ability to get an order from a judge without having to go through the normal motions process and everything that has to be done for the scheduling of it. So again, 14Bs, depending on what the moving party is asking for, it can be an order either without any notice to the other party, or it may be on the other party's consent, or it could be just a motion to deal with a number of various procedural orders. And depending on where you are, that will tell you whether you should be getting the other party to giving them notice and seeing if they're going to consent to it, or whether you can proceed on an uncontested basis.
We could go on to how to bring a 14B motion. That would be awesome. I think we're
Okay.
ready to do that.
All right. One of the first things I'm going to warn people about, and it's
Yeah.
horrible, and people are just going to roll their eyeballs, especially if they're in the middle of a court proceeding and they're trying to figure out if they've got something they can do by way of a Form 14B motion, which
Yeah.
is another thing, because a lot of the stuff we've been talking about are all things that you do at the front end of a case, like
Right.
before
Makes
case
sense.
conference or anything else. But you can bring a Form 14B motion, depending on what you're asking for, at any point as your application is progressing.
Right.
So it could be you might have already had your case conference and settlement conference, and you need to do something like, if you have to set up cross-examination of an expert or something to prepare for trial, and you're not sure what the process should be to set that up, you can bring a 14B on a 14B motion for directions on saying, what are the rules about how I can cross-examine this expert for the other side? So you can do a Form 14B at any point. So now what we're going to look at is we've talked about the different kind of things you bring a Form 14B motion for. You've got something that you think can be done by way of a 14B, and now you're just trying to figure out, okay, how do I actually do this? What are the nuts and bolts of how it works? So that's what we're going to go into now. How do you bring a Form 14B motion?
Right.
First thing, and this is where I started, people are going to roll their eyeballs. Every court jurisdiction does things a little bit differently, and the order that they do the forms and the things that they need. Like, for example, there might be some jurisdictions that specifically say, if you're bringing a 14B on consent, we need to have that form called a consent that you have to draft up because there isn't a set form for it in the family law rules. We won't accept an email confirmation that the other side's agreeing to something. You actually have to do a formal consent. There are other jurisdictions that might say, well, as long as you do your affidavit and you show that the consent is set out and you're swearing to it in your affidavit, that's good enough. So always what you need to do, depending on the region that you're in and what court you're going to, you should always read the practice directions and the notices to the profession that affect your area. Because the rules are in play right across the province, but as I said, different jurisdictions have got little quirks or things they want or need or whatever that they might not need in another jurisdiction. So make sure before you do your Form 14B that you see if your local practice directions or notices to the profession in your area has anything to say about what has to go in a Form 14B and when you can do it. So that's the first thing you need to do before you even start looking at trying to complete forms, is make sure this is actually going to work in your jurisdiction.
Got it.
So the first step you need to do is what you'd expect. You have to complete the Form 14B motion form. Okay.